So welcome everybody to the Refugee Welcome Collective Lunch and Learn. It's part of a series that happens twice a month. And in these sessions, we aim to bring you interesting and timely information. So whether you are a volunteer, community sponsor, resettlement agency staff, local advocate, or someone who's interested in learning more, you're all very welcome. And we hope that you enjoy today's session, which is titled Housing Tips for Refugee Newcomers, Tenants' Rights and Responsibilities. And so just quickly as a quick background, Refugee Welcome Collective, we are a national technical assistance provider. We collaborate with partners to provide in-depth training programs, learning sessions, resources, as well as on-demand technical assistance for sponsors, resettlement agency staff, refugees paired with sponsors, community and institutional partners, and as well as others to support quality community sponsorship programs across the United States. And I believe we have a housekeeping slide here. Yes. So I believe everyone joining is automatically muted. You are able to raise your hand, and if you have any questions, you can drop those in the chat. And at the end of the session, we will make sure that people can come on camera if they wish, or come on to ask any questions that they might have. So with that, I'm going to turn it over to Lynette Pearl with the Refugee Housing Solutions, which is I like to think of as our partner national TA provider here at Church World Service. And Refugee Housing Solution, in short, is a really great organization, and they provide resources, training, and support for resettlement practitioners, landlords, property owners, and refugees to expand access to quality housing for refugees, families, and newcomers. And as we all know, we are in a national housing crisis, so the supports that they give is really indispensable at this time. So with that, I will pass it over to Lynette. Feel free to add anything else you like, and I'll hand it over to you.
Thank you, David. I'm going to go ahead and share my screen. So please be patient with me and get us started. And please let me know if you cannot see my screen. So can you guys see my screen?
I can, yes.
Okay, cool beans. So today is I'm very passionate, as you guys know, about housing. But the one thing I'm very passionate about is housing rights. And the reason why, because when you know your rights and your responsibility as a tenant, you can be your best advocate. And it's great that we actually have, staff, resettlement staff, sponsors, volunteers that work side by side with newcomers. But when you know your rights, you can advocate for yourself. You are your best advocate. So that is the reason why I'm so glad that we're talking about what your rights are as a tenant. So I do want to let you guys know today is going to be, we have a Slido. So get your phone out to be ready to participate, because I want to make sure that you get the information, but also if you have some questions, we can talk about that at the end of the webinar. So the first thing I want to bring out is the contents of this webinar. They are just intended for informational purposes only, and it should not be relied upon as legal advice. So if you have a client that needs assistance regarding a legal matter, I highly recommend that either you get assistance counsel within your organization if you have legal counsel available, or refer them to a local fair housing agency. And the great thing about David and Welcome Collective, you do get the slides, but they also send you supplemental materials with these webinars. So you will get that information on how to find your local fair housing agency. So we're going to start with our first Slido. I want to know, what housing space do you occupy? And when I mean that, I want to know, are you a sponsor? Are you a volunteer? Or are you an actual housing specialist? Or you are a case manager? Because that would help me kind of tweak my presentation a little bit, knowing who the audience is, since it's so diverse. So let's go ahead and do our first Slido. Okay, I'm not getting any responses. Okay, I'm getting some. Some say rent. When I mean the housing space, are you a volunteer? Are you a sponsor? We'll go back to that. Um, okay, I have the rent. I want to know my audience. I want to know if you're a housing specialist, are you a volunteer, your sponsor? Okay, I guess it won't let me do it. So we're going to just move on. So on this is our agenda for our day, our learning objectives. You're going to learn what some pre-lease disclosures are. And you're going to learn what rights a tenant has during the move-in process and during the rental term. And even though landlords have responsibilities, tenants have responsibilities as well. So we're going to go over those. And also, what is the responsibilities housing providers and landlords have, regardless if they're a mom and pop landlord or if it's a property manager or if it's a conglomerate.
Lynette, just to let you know, in the chat, some participants mentioned that they're case managers, we have a potential landlord, and we have a sponsor.
Oh, great, great audience. We have a diverse audience. So landlord tenant disputes, they are common occurrence in the renting process, and some of these disputes can be avoided if a landlord and tenants are aware of their rights and responsibilities. That's where a lot of confusion can happen. So in order for a newcomer to be taken, not be taken advantage of, as I spoke earlier, they need to know their rights and how to advocate for themselves during the phase of the rental process. So we're going to talk about tenant rights. So depending on the state, there are some mandatory disclosures a landlord must reveal to an applicant before the lease signing. So there are rights that you have, a newcomer has during the application process and the lease up. I highly recommend you research your state laws for the mandatory disclosures. By knowing the state mandatory disclosures, you will know the type of issues and history of the unit or the home. And the landlord must report crucial information to the applicant that will allow them to make an informed decision before signing the lease. So there are some rights that you have before signing a lease. So due to time constraints, I'm going to only review a few disclosures that might apply to your state. Again, this list is not comprehensive, but it is a summary of some commonly required disclosures states may have. So we're going to talk about tenant's right to have a copy of the move-in checklist. So this allows a tenant to note damage they find in the unit that was there prior to moving in. So FYI, the tenant is responsible for filling and noting issues on the move-in checklist. So this document must be turned into the landlord so the tenant is not charged for the listed damages during the lease termination when they're moving out. Now, most landlords, they do have a time limit on when this document needs to be submitted. I do highly recommend when you're doing this list, when you're working with a client, is make sure they take pictures and keep a copy of the move-in checklist to make sure that there is accurate during the move out. Another best practice is to have the landlord sign off on the checklist so everybody's in agreement of what repairs need to be made. Another right that they have is to be present during their move out inspection. So at the close of the move out, landlords do inspect the property to see if there has been damage, whether the damage should be deducted from the security deposit. Landlords must inform the tenant that they have the right to attend this inspection. So that's why noting damages during the pre-lease and inspection, as I spoke about, is so important. Presence of environmental hazards. If the landlord knows that there are hazards levels of mold in the unit, the applicant must be informed prior to signing the lease. In addition, some states do require a notice of unacceptable radon levels and require the landlord to test for radon and provide the test results to the applicant. Another major disclosure is the lead-based paint disclosure rule, which requires either buyers and renters of housing built before 1978 to receive an EPA pamphlet, or it could be a state-approved version of the pamphlet. Now, the disclosure in this program, it aims to prevent lead exposure in children, families, and women of childbearing age. Another mandatory disclosure is the bed bugs. Some states and cities have bed bug specific laws requiring landlords to disclose a property's history of bed bugs if a prospective tenant asks. Others do require disclosure if no one asks. So nearly all the laws do prevent a law from renting or advertising a unit with a known current infestation. And this is a really important one, especially if you're working with newcomers with children, sex offenders. Now, this disclosure requirements vary by state, but landlords are generally required to provide tenants with notice about the presence of a registered sex offender in the area. Now, the disclosure may be in the form of a notice on the property listing, a separate disclosure form, or a requirement to direct tenants to a website where they can access information about registered sex offenders. Now, I know I'm talking to a diverse audience, but we're all in this to make sure everyone is safe. So best practices, regardless of what your state disclosure requirements is when it comes to sex offenders, I highly recommend that you do a check anyway. You could, of course, you have to sign off on the waiver. You can go online. But I highly recommend that is part of your best practices when working with your families. Another one is death in a unit. Now, landlords must inform prospective tenants if a former occupant died within the previous 3 years. They must also disclose how the person died, whether it's from natural causes, suicide, or homicide. Now, this applies even if the person who died was not a tenant, but if it was a guest of the tenant. Now, in some states, voluntary disclosures are not required, but if prospective tenants ask about it, they must be informed and their inquiry must be answered truthfully. Responsibility for maintaining smoke alarms. This is another important one. Landlords, they are responsible for providing smoke alarms that are in good working order when the tenant moves in. And however, depending on how your lease is, landlords may be required for you to keep up the maintenance. So that's why it's important that when you are leasing, when a client is leasing up, you make sure that all the smoke detectors are working. However, you need to ask the landlord or look at your lease, that they need to look at the lease to see who is responsible for maintaining it. And another, depending on where you live, is the flood disclosures. They're standard in states subject to flooding like Florida and Georgia. So the landlord must disclose if the unit has been damaged by flooding. Now, the reporting time, it does vary by the state, and some states only require notice if the unit was damaged by a flood 3 times in the previous 5 years. And there are some states that do require just a general notice if flood waters have ever damaged the unit. So we're going to go ahead and do another quiz. We're going to do a check-in. So the first one is, if a building is built before 1978, what disclosure must the landlord give an applicant? So I'm going to hit it and hopefully we can get some answers. And waiting for response. Grace, am I doing the Slido correct?
Yeah, it looks like people are putting their responses in the chat. So we've got,
Okay, they're not using the actual Slido. Okay.
yeah, it looks like this time we've got 2 answers for lead-based paint disclosure.
Okay. So correct. The answer, I was waiting for the results to pop up. So that is correct. Lead-based paint disclosure is the rule. So we're going to move on. So we're going to go on to the next question. Does a tenant have the right to participate in their move-out inspection? Yes or no? And I'm assuming it's being put in the chat, and I cannot see the chat. Grace, can you follow the chat for me? Are people putting the responses in the chat?
We've got 1 answer for yes.
And that is correct.
Another yes, yeah.
So yes, a tenant has the right to participate in their move-out inspection. So that's correct. So the biggest misconception I have known in this space is a lot of people feel, especially newcomers feel that they do not have rights under Fair Housing Act. So we're going to talk about the terms. Once a client is leased up, what are their rights? And the first one is they have the right to understand that the Fair Housing Act applies to them. Though they have rights under this act, it doesn't guarantee housing, but it does protect them from discrimination in a housing transaction. So they have the right to understand they do have rights regardless of their immigration status when it comes to the fair housing. They also have a right to have a landlord who follows the lease agreement. They have a right to submit a reasonable accommodation request and modification when needed. So, for example, if you are working with a newcomer and they say, hey, right now I possibly need a service animal, and say the building they're currently living in is a no pets building, they can submit they have the right to submit a reasonable accommodation for a service pet. And with that right, say, for example, with the service animal, they cannot charge them a pet fee or a pet rent, or a pet deposit, because it is a service animal. However, if the animal does make damages to the unit, they can take that out of their deposit. Another example of a reasonable accommodation is you're working with a client and you notice, for example, they need grab bars in the bathroom. That is considered a reasonable accommodation, and they have a right to have those grab bars installed in their bathroom without any cost to them. Or if, for example, they need just simply a parking space that's closer to their units, they can put it in a reasonable accommodation for that. So again, depending on the accommodation or the modification, the landlord cannot charge the tenant for the reasonable accommodation. A lot of people don't know that that is a right. They also have a right to live in a sanitary and habitable place. Now, almost every state law does entitle tenants to live in a safe and habitable housing, regardless of how much rent the tenant pays. Now, FEMA does define a habitable home as safe, sanitary, functional, and presenting no disaster-caused hazards to the occupants. So, what if the rental unit or home is unsafe and uninhabitable, or it does violate health or safety codes? So what rights does a tenant have? Well, under common law, because again, depending on your state, the tenant rights will vary, but I'm just going to go over the common rights. Under common law, every lease comes with an implied warranty of habitability. So this means that the unit must meet minimum living standards based on the housing code and local laws. Now, if the unit or home is uninhabitable, the tenant can possibly terminate the lease. Now, your landlord and tenant laws will outline specific rights in the course of action one can take when the unit or house is uninhabitable or it has major code violations. I want to point out, in some states, based on the condition of the unit and state law, the tenant may be able to withhold rent until repairs are made. Again, if this issue does arrive, I highly recommend that you refer the actual client to a fair housing agency or to legal aid to find out what their rights are based on your state. Possession and control of the property. This is a big one. Once the lease is signed, that's a legal document. It's a legal binding contract. The tenant has the right to occupy and control the rent premises without interference from the landlord, as long as the tenant complies with the lease terms of the law. Now, the right of possession does provide tenant with the freedom to live and enjoy their homes in legally permissible ways. Because of this right to possession, many states do require, and again, it depends on your state, it does require a landlord to give tenants prior notice of entry before entering into their unit or home. I have done some TAs where I have gotten some complaints from housing specialists, like working with the client, and they said, well, the landlord is constantly popping up. They're constantly popping up without notification. Now, again, it depends on your state. Some states require that they have to give the notice to entry. And if that's the state, I live in Missouri. In Missouri, you do have to give a notice to entry unless it is an emergency. Now, they don't have to. The notice to entry, it is a formal letter that the landlord gives the renter to inform the tenant of the landlord's intention to enter the residency on a given date at a specific time. So, for example, I live in Missouri. if a landlord is planning to have pest control, like regular maintenance of pest control, they would have to get a notice to the tenants that we're going to have someone in your unit to do pest control. Again, this varies from state to state. Receive notices. There's certain notices that you have a right as a tenant. If the ownership of the property is changing. So when a property is being sold, the current landlord must provide written notification to the tenants with the notice and with the new landlord's information. If there's going to be a rent increase, state laws vary regarding rent increases, but most states require that the landlord implement the rent increase until the lease renewal or unless the lease specifies otherwise. So that is why it's so important that a tenant knows what's in their lease so they know what their rights. So if you have a tenant and say, for example, there's a conflict that happens between the tenant and the landlord decides to retaliate and raise their rent at an unreasonable amount, they should go back and look at their lease because they have no right to increase the rent if the lease states that they have to give them a certain amount of notification, or the rent cannot be increased unless it's the lease renewal. So if the tenant and the landlord does agree, because there are some conditions for an increase in the rent, one of the examples would be if, for example, if I am renting from David, my colleague, and he says, well, based on our state laws and your lease, Lynette, you added another roommate, I am going to have to increase your rent by $50. If that's what my lease says, and he gives me sufficient notification based on our state requirements, that would be legal. It is illegal for a landlord, again, to increase one's rent out of retaliation. I want to really point that out, and discrimination, because I have seen that happen. Another big thing that if the lease will not be renewed. So if a landlord determines that they are not going to renew a lease, they must give the tenant a notification for, it's called non-renewal. Now, this notice period of non-renewal shall coincide with their notice to vacate policy. So, for example, I'm going to pick on my colleague, David. He is my landlord, and part of my actual lease says, my notice to vacate policy says I have to give him 30 days written notice if I am not going to renew my lease after it expires. So say if my lease ends December 31st, based on our lease and his notice to vacate conditions, I would have to give him written notice December 1st, because those are 30 days, and vice versa. David says, well, Lynette, I am not going to renew your lease. Guess what? He has to give me that notification the same amount of time that I would have to give him as well. So one thing people need to understand, a landlord is not required to extend a renewal nor give a reason. However, David is my landlord again. If he refused to renew my lease due to discriminated reasons or out of retaliation, that goes against the law. So I'm going to talk about what discrimination in housing means. Is when a landlord or housing provider treats an applicant or tenant differently from other applicant or tenants in a way that it violates the Fair Housing Act. Or if retaliation in housing is when the landlord or housing provider does not renew a lease because the tenant asserted their rights during the rental tenure. And so examples of that would be, again, I love examples. I'm Dave's tenant, and Mr. David is not doing my repairs in a timely manner based on my lease. And I file a complaint against Mr. David. So Mr. David decides, well, because of that, I'm going to retaliate against Lynette and not renew her lease. So, or again, if I participate or file a complaint with a government agency regarding the conditions of my unit, and David decides again, well, I'm not going to renew Lynette's lease because of those. So these are things that it's illegal for a landlord to do for not renewal. So just FYI. And again, if you have a client that has any questions and concerns, please refer them to a legal aid. So I'm an example type of person, and this is what this is one example of a notice to enter a unit. So this is what it looks like in general. It gives the time, the date. It'll tell specifically when the date they're going to access the unit and the approximate time. This is pretty much all, but it's a good example. And it thanks the occupant in advance that the fact that they're going to be entering the unit. So this is an example of what that looks like. So we're going to do another quiz. So I have this in Slido, but name some rights a renter have during their rental term. And David, can you please check the chat for me if people are not using Slido?
Absolutely.
Are we getting any responses?
Not yet.
Okay, I see participants typing. I'm going to move on and then oh, here we go. People are using Slido. Yay! Yes, submit reasonable accommodation request, inspection. Yes, disclosure of, okay, cool, proper notice. Yes, 30 days rent notice. Now, I want to point that out. Someone says 30-day rent notice. I use that example. Your state will determine the amount of notice that has to be given for the non-renewal. So the example I used was 30 days because some states is 30 days. However, some state does have 60 days. So I do want to point that out. So that 30 days is not a concrete number depending on your state. So that's why it's so important when I tell people that's in the housing field, know what your state and local laws are because they could be more stringent than the overall laws. So I'm glad someone picked up on the 30 days, but I want to point out depending on your state and the lease, it can be 60 days as well. So even though we're going to talk about something that is very ugly, but it does happen, even though states does have different eviction process and timelines, the reasons for some evictions, they're primarily uniform across the state. So we're going to talk about some offenses that are can cause a landlord to evict a tenant. And the biggest one, of course, is failing to pay rent is one of the most common reasons tenants are evicted. So if the tenant fails to pay rent when it is due, the landlord can give the tenant a written demand for the rent. This demand must inform the tenant that rent is due and that if the tenant does not pay, then the landlord will terminate the lease. So if the tenant does not pay rent, the landlord can go to court and file an eviction lawsuit against the tenant. There's a misconception that if you're behind on rent, you get a notice to vacate, automatically the landlord has the right to evict you right then and there. And that's not true. There is an actual legal process, and we're going to go over that. Again, depending on your state will determine the time frames, but we're just going to go in general, the flow of what an eviction looks like. Another thing is lease violations. Now, since a lease is a contract, a lease violation is legally breaching a contract. So a lease violation can occur when the tenant does something that the lease specifically prohibits. Now, one lease violation is not grounds for an eviction unless it is egregious. So with a lease violation in most states, the landlord, again, is required to give the tenant reasonable time to correct the violation before pursuing an eviction. I want to say this, again, depending on your state, a landlord must give a written lease violation notice first. Now, if it's something egregious, then they can start the eviction process. An example of a lease violation is housing unauthorized tenants. Now, the lease should have a guest policy. All leases should have a guest policy with the stay-in terms. So if those terms are violated, the individual is no longer a guest, but becomes a trespasser. So that would be a lease violation. Damage to property. This is beyond regular wear and tear. If a tenant is purposely destroying a property, the landlord can take action depending on the situation. It is a landlord's responsibility to keep all tenants safe, so a landlord has the right to terminate a lease if a tenant engaged in criminal activity on the property. Because criminal activity, it can range from minor misdemeanors to serious felonies, it will be difficult for me to address them all. However, in this webinar, I'm going to go over a few examples of criminal activities that could warrant an eviction, an instant eviction. So, for example, drug-related offenses, prostitution, assault, domestic violence, and theft. The severity of the crime and its impact on the community will determine the urgency of the eviction. Now, I want to point out with domestic violence, because I don't want any confusion with this. With domestic violence, this does not apply to the victim. Now, if a tenant or a household member is the victim of the domestic violence or harassment, sexual assault or stalking, the tenant is protected under state laws that vary. And they're also protected, what we call is VAWU, which is Violence Against Women Act. Now, when I want to go back to VAWU has been evolving since it came out. Because it is Violence Against Women Act. This does not mean it's just specifically now for women. So I just want to point out the VAWU Act has expanded to include male victims of domestic violence as well. So now I want to point this out. A victim does have the right to terminate the lease for safety reasons. So if you're in a lease, there are some terms, it's called early termination. There are some financial consequences if you terminate your lease early. However, if you have a client that is a victim of domestic violence, they can terminate their lease without financial consequence. The landlord would have to let them out of the lease. One of the things I have found when I was working with victims of domestic violence, when we had to do the lease termination to move them to a safe area or a different area, usually the landlord only possibly sometimes they will request a police report, or if the client does have an order of protection, that's all the documentation they need to terminate the lease. Now let's talk about the person, the abuser. They do have every right to start eviction or consider them as a trespasser on the property, especially if the victim has an order of protection. So just FYI, with that, if there's some questions, please contact your local domestic violence agency, get them some support because they're more knowledgeable on how to handle housing when it comes to something so sensitive like that, especially if it's someone in the household that needs to be removed. And sometimes with that, it can be a sticky situation for the landlord. So provide them as much support as well, not just for the client, but also for the landlord when it comes to the legal matters of that. And I like examples, and this is what a notice of a lease violation looks like. So if a client gets one, I've had clients get a lease violation and they freak out. Oh, I'm about to get evicted. And I'm like, let me read it first and let me see what it is. And I'm like, oh, it's a lease violation. However, if you get more of these, then yes, you're going to set yourself up to be evicted. So this is what a lease violation looks like. And this is what a demand for rent looks like. So again, I will have clients, when I was a housing specialist, sometimes I would have clients freak out. They would get a notice to vacate because again, states do require that there's a process before you can start evicting a client. And one of them is to give them a notice to vacate. So they would freak out when they see this, like, okay, I'm gonna be evicted tomorrow. It'd be like either a 3-day notice or a 10-day notice to vacate. And I'm like, well, technically, no, they're just giving you time to rectify the situation, but they have to start their paper trail. We're going to talk about what rights the tenant has when it does happen. They have, under U.S. law, landlords can terminate a lease for reasons, as I mentioned earlier, such as non-payment of a rent, lease violations, and criminal activity. Your state does determine the notification requirements in the process. While the specific details of the eviction process vary from state to state, tenants have general rights such as they have due process, as I talked about. The landlord has to follow the respective state's formal eviction procedure. Regardless of one's financial situation, one deserves legal assistance and representation. So if you have a client that receives an eviction notice, please, please, please help them seek legal assistance as soon as possible. I recommend referring them to a local legal aid agency that can provide them free or reduced fee legal services. I just want to point this out, legal services, they do vary and may include either legal advice and representation. I have seen legal aids actually come to the court hearings with clients, but I've also seen some say, hey, we're just going to give you advice and these are some tips. So it does vary. FYI, some legal aid services may have wait lists, so that's why it's so important if a client does receive a notice to vacate, because that's the first process of starting the eviction, they seek legal assistance or reach out to their legal aid to tell them, okay, I got a notice to vacate. Can you please get me in as soon as possible to get some services? Now, one thing I didn't talk about is retaliation. I just scammed over a little bit. But again, this is a process. An eviction is a process. So a landlord cannot change the locks. They cannot shut off utilities, and they cannot remove a tenant's belongings until a legal court order has been issued. So I have seen it. I have seen tenants literally be locked out of their actual units without the landlord going through the actual legal process because they didn't know their rights. So a landlord cannot do that unless it has actually went through the legal process. So we're just going to, as stated earlier, I want to just point this out as always, because I'm just giving you general information. Depending on your state will determine the notification requirements and process. While the specific details of the eviction, again, varies from state to state, there are general rights a tenant has in the eviction process. So before an eviction is filed, a landlord must serve the tenant with a notice to vacate letter, which I had showed you as an example. So once the tenant receives a notice to vacate, they can either comply by moving out or by paying the arrears. If they choose not to comply, then the eviction process continues with the landlord filing a complaint with the courts. Now, depending on the state again, the state law, the tenant is served by a constable. So once the summons is served, they must attend eviction court. And again, depending on what happens at the court, it will determine the next step. So if the tenant wins, they can stay during the duration of the lease. And if the landlord wins and the eviction does go through, the tenant will be given a specific amount of time to move out. So what happens if the tenant does not vacate the property during the designated time given by the courts? Well, then the landlord then has legal right to call the sheriff and have the tenant belongings physically moved out from the unit. So this is kind of general eviction roadmap. And so we're going to talk about move out rights. We're going to wrap this up a little bit. As I stated earlier in the disclosure portion, I did talk about this. Tenants do have the right to be present during their move-out inspection. So the move-out inspection should be similar to the move-in inspection. The client should have a copy of the punch list used for the move-in as a comparison. And clients should do the walkthrough with the landlord to dispute any damages that are not basic wear and tear. So once damages have been agreed upon, and if they do not exceed the deposit, a client should request the remaining balance. Now, the lease does outline when the landlord has to return the deposit, and landlords cannot charge for basic wear and tear. So know your basic wear and tear laws for your state. Ordinary wear and tear means that those repairs that need to be made just because someone has lived in the home. Again, depending on the respective state, some landlords are required to keep the tenant's security deposit in an interest-bearing account. So often the rules may include notifying the account's location. So if you're in one of those states where if your landlord is required to hold your security deposit in an interest-bearing account, they have to inform you where that account is located. is some states do require that if the landlord holds a security deposit for more than a year, they must pay the tenant interest. So just FYI. And another thing is your lease and your state will determine if a security deposit is returned, when is a reasonable time for the landlord to return it to the tenant. So let's do another quiz. A tenant cannot receive legal assistance or representation during eviction process. Is that true or false? It's false. As I stated earlier, regardless of one's financial situation or immigration status, they have the right to have legal assistance and representation during eviction process. And the next question is, name some evictable offenses. So hopefully we can get some participation on that. And David, how am I doing on time?
You're coming up at 12:44, so if
Okay,
you want a little room for questions.
okay, I'm wrapping it up. Damage to property, that's yes, correct. I see people don't pay rent and drug offenses. Correct. So I'm going to go ahead and go through these other ones quickly due to time. We talked about what tenants' rights are, but you know, as a tenant, they have responsibilities too. Again, to pay the rent on time, to keep the apartment or house safe and clean, not to damage the apartment or house, respect their neighbors, provide a safe environment, make timely maintenance repair requests. You can't expect a landlord to keep the unit inhabitable if you're not letting them know that maintenance or repairs are needed in a timely manner. And understand emergency versus a non-emergency situation. And then landlord responsibilities is to adhere to the Fair Housing Act as well as a tenant to cover state required disclosures. They're responsible for following the terms of the lease and the rental agreement, such as the tenant as well, and manage tenant relationships. Because when a landlord communicates effectively with their with their tenant, it makes the whole rental process run smoothly and make the property inhabitable. They do timely repairs required by local, state, and federal laws, provide safety measures, and abide by the occupancy standards. I want to point this out because sometimes I do know, especially in this resettlement space, people think landlords are being unreasonable, especially if they're housing larger families. Please get with your local housing authority if you have questions about occupancy standards, because some landlords, they're not trying to be cruel, they're not trying to be mean, but they're just following the occupancy standards in that particular area. So just FYI. And we got one more and we're out of here. Who's responsible for adhering to the fair housing laws? Is it the tenant, is it the landlord, or is it both? It's both. So I'm going to go ahead and answer that for you guys because due to time, it's both. It takes two to tango. It takes two to make sure it's a good relationship. Both are responsible for adhering to the fair housing laws. The tenant to know what their rights and laws, their rights are under the fair housing, and the landlord to actually practice them as well. Who's responsible for making timely maintenance and repair requests? Is it the tenant or is it the landlord? It's the tenant. Oh, it's a 50-50. It's the tenant because the landlord can't make a repair unless he knows about it. So the tenant needs to make those requests for making a timely request. Well, I guess it could be both. I could see from both perspectives. So I probably should have worded that differently, but I can see both. Oh, you did a good job, Herman. And so that concludes this webinar. And I'm going to go ahead and pass it back over to David.
Great. Thank you so much as always. That is very informative. So yeah, I think in maybe just like the 10 or so minutes we have remaining, we'd just like to see if you have any, if anyone wants to come off or drop any questions in the chat. And here's an opportunity to hear directly from Lynette. And as I'm sure Lynette will remind you, through the Refugee Housing Solutions website, you can also, or even emailing her directly, you can always schedule a one-on-one TA session as well.
Absolutely.
All right, so I think now we're moving over where people can come off mute if they'd like to ask any questions.
And I want to just add this, put it out there. Guys, please, please, please. I know David's really good about giving surveys. We need your feedback, regardless how brutal it is. I have tough skin. This helps us know what type of materials to present to you to make sure you have the tools to be successful in the field. So please, after this webinar, give him your feedback. So I'm open to questions. And sometimes people don't like to do questions in an open forum. So if you want to, feel free to email me. If you do, after you think about it, you can email me at lpearl@cwsglobal.org. Someone has their hand up, I think.
Yeah, I see a
Hello, my name is Barullah Nori.
Hello, how you doing, sir?
Sorry for being so late. This is my first time ever being, I wasn't sure it's gonna work, but this time, so I came too late. I'm really sorry about that.
No, that's okay. We got busy schedule. At least you came. That's all that matters.
Yeah, but I'm from Afghanistan and I came here and I have a lot of questions about like and I have a lot of issues with the rent and how exactly the rents and the lease questions that how it works here exactly, and like I exactly have no clue about those things. Like sorry about like this. It's probably not the time to ask
No, no,
those
no, no,
questions
no.
because it's
No,
already
no,
being too late.
don't apologize. What we can do, we can get you my email, and you can email me. We can set some time to do some TA, and we can walk through your questions if you want to do that.
Yeah, that's also works. It's gonna be really good. So I just see this somewhere it's like come on odds. This like refugee welcome collective, and I I thought let's try it, and then yeah, it did work, and you know.
Now, do you have access to the chat? Can you see where my actual email is so you can contact me and we can set something up?
Uh, I don't think so. Like I don't know it's the exactly thing, but if you email me, so that would be like give me another notification and I
Okay.
can reply. So that would be great. Thank you so much for doing that.
I don't want to lose you, but I guess if you register, we have his email in
Yes.
the registration, don't we, David?
Yeah, I'm taking a note,
Okay.
Bahula, and we have, because you registered and you're here, we have your email, and so I will make sure as soon as this call is over that that Lynette has that and can follow up with you immediately to set some time up so you can have the time that you need to talk through your questions. Thank you.
Yeah, thank you so much, guys, for doing that because especially our Afghans brothers, they and sisters, they have too many questions and problems, especially those who does not understand English and they don't know how to speak English. That's such a big problem for them, and as well as to me too, because it's kind of totally different to being in a different country and different like the system and culture and the way they like uh things works. So yeah, it is a problem that they most of the people they don't know how to have a secure place and all those fulfillments. and all those needs. What's the needs for the rent and what should they do? So they as also don't know, and I think this is the topic and the purpose of this webinar. So as I read.
And I think Miss Linda, thank you for reaching out. And I will reach out to you. I think Miss Linda has her hand up. Linda, I may help you.
Yes, we have a family that's coming from the Ukraine, March 2, and we're going to be looking for a place for them right now. And I think within the couple, one does speak some English. So in order to get I would like to have them view this webinar. So do we go to refugeewelcome.org?
Yes, if you want to see a recording, it will be posted on our website in our resource library. And also because you've registered, we will follow up with you probably within a day, if not less, with a follow-up email and a recording of this session.
Okay, super. Okay, that's great. Thank you so much. I appreciate it. Thank you.
And again, if you have any questions, feel free to email me at lpearl@cwsglobal.org. And also go to our website. Our website, we have also Refugee Welcome Collective. We also have tons and tons of resources. I have a lot of colleagues that are very knowledgeable in this area of housing. So there's a team of us. So there is also not just webinars, but also toolkits we have. I want to promote our tenant toolkit. We do have a tenant toolkit where it breaks down the whole rental process and rights and what to expect when you're renting in the US market. So I do advocate that if you are working with a client, get them the tenant toolkit, or even if you're going to be recruiting a new landlord, we have a landlord toolkit. And the perspective of that landlord toolkit is how do you work with this newcomer population to make sure that it's a good relationship. And the one thing about our tenant toolkit, it is in 9 different languages. So the very things that I spoke of, we go deeper, and it talks about, their rental rights, what to expect during their tenure, how to even fill out an application, how to actually put in, like, what to expect of a maintenance order. Is the whole cycle of the rental operations.
Lynette, we have a question that's in the chat, so I don't want to miss it because it certainly seems like a rather critical one. But the question is, and I believe it's coming, I can't see the full name, but it's how can we protect / advise refugees that are facing a situation when the landlords are not willing to provide a lease, but still collect payment for rent?
Now, depending on your state, some states not required to have an actual written lease. So oral leases can be legal in certain states. However, I do, even if it is legal, I still would require a written lease to cut down on confusion. We had a TA where we did have one of the affiliates. They were in a state where oral lease was recognized as being a legal lease. But they said, well, in order to work better, to make sure there's no confusions, because there's a nice way to go about it, can we just go ahead and get a written lease to make sure that we're all on the same page? But I just want to point that out. Some states it's considered a legal, oral lease is a legal lease. I wouldn't recommend it, but because when disputes do happen, you don't have anything writing to hold the landlord to the fire, unfortunately.
Lynette, we have just a few. Oh, I see Maureen has her hand up. Please go ahead.
Can you just please repeat the information where we can get this tenant tool information in all the languages? And is Swahili one of the languages?
I think so, yeah.
And where do we find that? Where will I
Grace
find
is
that?
my eyes and ears. She's also one of my colleagues. She's on both team sides. I think, Grace, did you put it in the chat, Grace?
Hi, yeah. I did put the link in the chat to our resource page that has all of the tenant toolkits, both in English and then the additional translated versions.
Yep, I see it. Thank you.
Any
We
more
just got
questions?
probably less than 2 minutes at this point. If anyone else has a a real quick question, please go ahead. Okay, well, I think just want to thank again our presenter Lynette today, and thank you for everyone for attending today's RWC Lunch and Learn. You will, as I mentioned, receive a follow-up with a link to the recording of today's webinar, and of course, we always value your feedback. So again, I will drop in the chat the link to the survey. That certainly helps us to improve our offerings, and there's also the QR code currently on the screen. And so again, just on behalf of Refugee Welcome Collective, thank you so much for joining us, and I hope you all have a great start to the week. Thank you very much. Great, I think we can, with just a few minutes past 12, maybe we can just give it one more minute before we start. Just allow others to join, and we'll start very soon. Okay, I think we can start. Hopefully others will join.